Now on to our program. It's my pleasure to introduce James, also known as Jamie Doherty Jr., a respected healthcare attorney and friend to Montgomery County Medical Society and our members. He is a principal in the Maryland law firm of Pecor and Doherty, a boutique law firm focusing his practice on representation of individuals and entities in the healthcare industry, including individual, group, and institutional healthcare clinicians and vendors. Mr. Doherty was formerly Vice President and General Counsel of New American Health, a Maryland Medicaid HMO, and served as the Senior Counsel for Integrated Services at the Johns Hopkins Health System in Baltimore, Maryland. He has practiced in-house for a Fortune 500 proprietary hospital chain and was a contributing editor at the American Health Lawyers Association in DC. Mr. Doherty maintains a faculty appointment at the University of Maryland Francis King Carey School of Law, where he teaches healthcare law and policy. He taught the course Legal and Ethical Issues in Health Services Management for 17 years at the Johns Hopkins University Bloomberg School of Public Health. Mr. Doherty is past president of the Board of Trustees of the Baltimore Medical System, a community health center in East Baltimore. Mr. Doherty is a graduate of the Columbus School of Law at Catholic University of America in Washington, DC. So just a reminder, we will be offering those questions first to Jamie at the conclusion of his presentation. And so please put those in chat, and then we invite you to use your microphones and ask additional questions. So we ask now that you turn your attention to Jamie Doherty as he shares his expertise on employer-physician contracting and exactly what to look for in the fine print. Jamie?
We're just going to talk about employment issues, whether you're a physician who's considering going into a different employed situation, or whether you're physicians who are planning on hiring physicians. These are just some of the basic legal structures that are involved in doing that, and I'll be happy to answer questions at the end. So the purpose is to give you some insights into the business side of medicine, the different practice settings we see in our practice, the employment contract issues, and some tips on when and how to choose and use a lawyer. Our practice represents healthcare providers, virtually exclusively, primarily physicians, some hospitals. So the practice settings we see are academic medicine, faculty practice foundations, direct employment by hospitals, direct employments by independent medical groups, and direct employment by managed care companies like Kaiser. This is something I'm not going to spend time on, many of you may be aware, in the state of Maryland, there's generally only two types of legal entities you're allowed to practice medicine in. That's either a professional corporation, PC or PA, or a limited liability company. If it's a hospital-owned corporation, it might be a different type. It's just something to be careful about. We literally just had a physician who formed the wrong type of corporation, which the board of physicians might say is practicing illegally, which CareFirst might say we want our money back because you were billing in an improper corporate form. So there are ways to fix that, but it's something that you would just rather avoid. So I'm going to talk about the difference between an employment contract and a letter offering employment at will. Employment at will is what an awful lot of people are used to. That basically means, there's no continued expectation of employment, that you can be fired for almost any reason or no reason, and you can quit for almost any reason or no reason. You can't be fired for reasons that are otherwise illegal. You can't be fired because you're disabled or pregnant or Muslim. But other than that, people can fire you for almost any reason, and you can walk away for any reason. All right, employment at will versus employment contract. So if you get a letter offering you employment at will, which it will usually state, that will say, this is your position, this is your salary, here are your benefits, your time off, all that kind of stuff. But it will often, if it's written by good lawyers, will say, this is not an employment contract. This is just a list of sort of the deal that we have. It still means you can quit and they can fire you. An employment contract does give you an expectation of continued employment on whatever terms it says. If it says they have to give you 90 days notice to terminate you, then you are legally entitled to 90 days notice. If they want you to leave immediately, they have to pay you out for the 90 days and ask you to leave immediately. So anything that's in the contract is now legally enforceable. And we'll sort of talk about that. The thing to be careful also about employment contract is every contract will have a provision in it that says this contract is our whole deal. Nothing else we said, nothing else we wrote is part of our deal. So if you had phone conversations, emails, letters, and then after that you sign an employment contract, all of that stuff goes away. So if there was anything in your communications with them that you wanted to be part of your deal, you need to make sure it's in the final written agreement, because if it's not, as far as the law is concerned, it doesn't exist. One question to ask is, do you want an employment contract? Do you want the ability to walk away fairly easily, or are you looking for a long-term commitment? I mean, what are your goals in this relationship? So the importance of a detailed written agreement: forces parties to raise and address all important issues in advance, avoids inconsistent expectations, minimizes opportunities for later disputes. And this one, I've been doing this for a long time. This one's really important. Provides insights on how well you and your employer will work together. If you're negotiating an employment contract and they are intractable and unreasonable and won't negotiate with you, that's kind of how they're going to be in your employment relationship. If they're reasonable, they listen to you, they make some changes, they understand where you're coming from, that is how your relationship's going to go. I've never been part of a contract negotiation that was a very tense and unpleasant contract negotiation that turned into a very collegial professional working relationship. The unwillingness of employer to put oral promises in writing is a red flag. I had a physician recently who wanted to start a family. She wanted 12 weeks of unpaid maternity leave, like you get in the Family Medical Leave Act. And the employer said, well, we're not legally required to give that to you. And she said, well, that's fine, but I want it in the contract. And they said, oh, don't worry, we'll give it to you. We just don't feel like adding it to the contract. And I said, it's a sentence. It's a sentence that goes in the contract. And it was very, very important to this physician client. So we got them to put it in writing. But for them to say, sure, we'll do it, but we're not going to put it in the employment contract, that really means you have no legal right, no matter what they told you they would do. You have no right to enforce that promise, because that promise is not in your contract. As a general rule, the smaller the employer, the more likely they are to negotiate changes with you. The larger the employer, if you're going to a Kaiser or a Johns Hopkins or some very large employer, unless you're bringing something unique, some kind of specialty clinic or something, some service they don't otherwise offer, they're going to give you a standard contract. It's still important to educate yourself about what's in it. It's got a lot to do with your money, your benefits, termination provisions, what happens post-termination, who pays your tail coverage, is there a restrictive covenant? So even if the employer says this is kind of a take it or leave it contract, our advice is really understand what you're signing. All right, so we talked about this. Determine what your individual needs are and goals are, security versus flexibility. I had a physician recently got an offer to go to Hawaii and work as a physician for a military subcontractor, and they were going to pay all expenses. She'd get her own free apartment. And, I said, do you want a long-term contract? She said, no, I've always just wanted to live in Hawaii, and a year's plenty. So she didn't want a long-term contract. So what are you looking for? If, on the other hand, you're going to an area where that's where you want to start a family, you want to have kids and have them in those schools, then security is a lot more important to you. One size doesn't fit all. A contract that's good for you might not be good for somebody else. So your duties and responsibilities, on-call coverage obligations. A lot of physicians, they look at a contract and think, what's my salary and bonus? What's my call coverage obligation? And then you're done. But there's another 15 pages worth of stuff there that you really need to educate yourself about. So try to make sure it includes what you want to do. It excludes what you don't want to do. This next one is important, and we'll talk about it more when we talk about restrictive covenants. Specify sites if the employer operates at several. There are practical and legal considerations. So if you think you are working at a site that's 15 minutes from your home, and they change their mind and say, no, we want you to work at the site that's an hour across town, you just lost 2 hours of your day. That's a really important thing to a professional. It also becomes important with regard to restrictive covenants, which we'll talk about a little bit later. So if you have an agreement that you're going to work at a particular site, you need that in writing. Otherwise, they can now every once in a while, they might want you to cover a different site. There's a physician who's out with the flu or COVID or maternity leave. that's fine, but you should know what your primary practice site's going to be. All right, the employer's obligations give you space and equipment. Do you have adequate support staff? Do you use, ancillary providers? Do you usually work with a nurse practitioner, physician assistant, medical assistants? Their obligations give you salary, very often bonus, benefits, and malpractice coverage, which we'll talk about in a little bit more detail. Compensation is, I'm not really going to address that tonight. That's going to be in the second session next week. So your benefits package, malpractice insurance, and there are two types that you may be familiar with: claims made versus occurrence. Occurrence is the best kind. It's usually more expensive. If you go to a Johns Hopkins or an UMS, you're probably going to get occurrence coverage. And what that means is, if the alleged malpractice occurred while you were covered, it doesn't matter when the claim was brought. So if you're a pediatrician and there's alleged malpractice, but the claim isn't brought for 10 years, so the kid was 8 and they can wait until they're 18, you're covered under occurrence coverage because the incident occurred while you were covered. Claims made is a lot cheaper and a lot more common. What that says is the claim is they will only cover you if the claim is made while the policy is currently in force. So if you have a 1-year policy and the alleged malpractice was in January, they bring a claim in December, you're covered because the claim was made during your year of coverage. If you leave that practice and go somewhere else, so you're no longer covered under that malpractice carrier, and a claim comes in for an alleged January malpractice the next February, you're not covered because the claim was not made during your 1-year policy. So the way that gets handled is sometimes it's called an extended reporting endorsement. It's most commonly called tail coverage. It's a separate policy that you buy with claims made that will cover claims that come in after you're no longer otherwise covered by that carrier. Now, the question is, when you leave someplace, who pays the tail? And the tail, the amount of the tail can vary widely by specialty, by how long you've been practicing, by your malpractice claims history. But who pays for it is important. If you leave and the employer, a large place like Hopkins or Maryland will virtually always pay your tail. But I've seen contracts that don't say who pays the tail, and it can be expensive, depending again upon your specialty and these other factors. So the contract should say who pays the tail when you leave, and it can be dependent on how you left. Some contracts will say, if you voluntarily quit, you pay the tail because that was your decision. If we have to terminate you for cause, you pay the tail because you were the one who caused the termination. The flip side of that might be, if the practice just terminates you for no reason, they'll pay the tail because that wasn't your fault. Or if you have to terminate them for cause, they didn't pay you your contractual bonus and you terminated the contract on that basis, well, maybe they should pay the tail because the termination was their fault. It was up to them. So there's no standard on this. Sometimes the physician always has to pay their own tail. Sometimes it's what I just described. Sometimes it's a sliding scale depending upon how long you've been there. They might split it with you, but take a look at it because I've had a number of physicians who leave, suddenly find out they have to pay $10, $20, $30, $40,000 tail, and it's a surprise to them. You get paid leave, extra time for CME, health insurance, short and long-term disability, life insurance. For some of these health insurances, if you have your own, if you don't need health insurance because you're covered under your spouse's plan, or you have your own personal disability insurance or life insurance, you might try to negotiate with the employer to say, if I'm not going to use some of your benefits, maybe I should get some extra salary. And they might have you sign a waiver document because they're required to offer it to you, but just something to think about. Some employers will do that, some will not. Pension and profit sharing. If you're going into a new pension and profit sharing plan, do you want to consider rolling your current pension assets into the new plan? If you have a financial advisor, you should really talk to them about that. Our firm is not financial advisors, we're not tax people, but just something to consider. Are they going to pay professional dues and subscriptions that you need to maintain your society memberships, to maintain your fund of knowledge? How does the CME work? Is there a cap of X $1,000s per year or a minimum allowance, and they will authorize more depending upon the meeting? And another issue is insurance portability. So if you have life insurance or disability insurance through your employer, can you pay an extra premium and take it with you? Or does it completely terminate once you leave that particular employer. Okay, in most medical practices, there are two types of physicians. There are the, shareholder partner physicians who own the practice and work there. And there are physicians who are just employees or independent contractors. So when you're negotiating these things, if you're interested in that, at what period do you become eligible for consideration? What conditions have to be met first? Do you have to meet certain financial targets, patient satisfaction surveys, local presentations, community activities? What does it require? Does the contract specify a buy-in price or formula? If it doesn't say a buy-in price or formula, you have no guarantee. Be very careful if you're taking a lower salary in exchange for a future right to buy in. Another thing to take into account when you're thinking about buying into a practice, it's kind of like selling stock. So if the practice has a book value, and I'm just making up numbers, of $10,000 or $100,000, and you are going to become a 10% shareholder, you would generally have to give them $10,000 to buy your shares. If the practice looks at you and says, you know what, we like you so much, we're just going to give you 10% of the practice. Well, that's great, but the IRS says you just made $10,000. You've gotten something worth $10,000 and you're going to have to pay taxes on that. So if you didn't buy in yourself, just do some financial planning for the tax implications. Also, how do you buy in? Is it a lump sum payment? Can you negotiate installment payments under a promissory note? I've seen arrangements where they basically said, look, we'll let you buy in, but what you're going to do is sort of forfeit your bonus each year until your bonus forfeiture reaches the buy-in price. So just, how's that buy-in going to be structured? They're just going to have cash flow implications. Indemnification is in virtually every contract, and that just means each party is responsible for their own legal harms. So if you are sued because you sexually harassed somebody, a patient or a staff member of the practice can say, if we, the practice, get sued for that, you indemnify us. That's something that you did. So if we get sued, you pay our legal costs, you pay our legal fees. If there's an award against the practice, you pay it. And the flip side is if you get sued for something they had control over. If Care First sues you for fraudulent billing, but they were in charge of the billing, you had nothing to do with billing, you just provided the services and made your entries into the EMR, they should indemnify you for that. So the basic point is you want the indemnifications to be equal. You're equally indemnifying each other. If they want you to indemnify them, but they're not indemnifying you, that's something to talk to your lawyer about and work out some different language. So restrictive covenants. This is a very active area of legal dispute. And what that restrictive covenant basically means, when you leave an employer, they may have a provision in your contract that says you can't practice within a certain period of time, within a certain geographic distance from us. We helped you build a patient base. We helped you, integrate yourself into the local medical community. What we don't want is for you to work for us for a year or two, move across the street or even in the same building, hang up a shingle and start stealing patients from us. So non-competes are enforceable in Maryland and many other states as long as the restrictions in time and distance are reasonable. I had a young resident come out of Maryland, and she went to this small practice out in Western Maryland. And they said, if you leave here, you can't practice anywhere in the state of Maryland for 10 years. And that was just unenforceable. The courts would not enforce that. 10 years is ridiculous. Usually see 1 to 2. On the entire state of Maryland, a practice in Western Garrett County doesn't compete on the Eastern Shore for patients or referrals. So we negotiated that down. Courts will consider what role did the employer play in building your reputation, your sources of business, what's your employer's service area, where do they derive most of their patients from. There's no hard and fast rule on this. One way we like to think of it is if you took all the patients at that employer and punched their zip codes into mapping software, and you drew a circle around the location, sort of the service area might be where 75% of the patients come from. That's their primary service area. Outside that, they have some patients, but that's not their primary area. That's not a hard and fast rule, but that's just a way to think about it. And the courts will look at, are they trying to protect a legitimate business interest? I had one physician who was double boarded in internal medicine and cardiology. and they were with a cardiology group. He had a restrictive covenant, and he left, and he said, you know what, I'm not going to practice cardiology anymore. I'm just going to do internal medicine exclusively. And the practice tried to enforce the restrictive covenant. And the court basically said, you're a cardiology practice, you're not an internal medicine practice. So this person, you don't have any legitimate business interest you're trying to protect. This physician is no longer competing with you. So the court refused to enforce the restrictive covenant. What does it cover? It will cover your professional services. Can you practice medicine within that area for that period of time? It may also cover management and administrative services. Can you be a practice manager at a different practice within that area? Or even if you're not practicing, can you own a competing entity, in that area? So the non-compete is usually expressed as a mile radius around a particular site. It could be a map, it could be by county, it could be by zip codes. I most typically see a geographic radius. And be very precise. It's got to be the exact geodesic distance. If you think you're getting a new job outside your restricted zone, you need to be very precise about that. I had a physician a couple of years ago thought she had a 5-mile restrictive covenant. I asked her several times, is your new job outside the 5 miles? She said yes. She took the job. She was relying on MapQuest distance, and she was actually 4.8 miles from her old practice. They sued her. And she had to give up her new job, and she was doing locum tenens work for a year or two to get back on her feet. So if you're thinking about going somewhere that you think is outside your restricted zone, be very, very careful about it. And also, if you're leaving someplace and you have a restrictive covenant, your new employer is going to want to know that they are not helping you violate your restrictive covenant, because they can also get sued for something called tortious interference. So they hired you, you're in violation of your restrictive covenant, your old practice is going to sue you for violating the restrictive covenant. They're also going to sue your new employer for essentially conspiring with you to violate your restrictive covenant. So how long is the distance? It varies greatly depending upon sort of a population density, urban versus rural. If you're in a densely populated, city or county area, it might be 5 miles. I've seen restrictive covenants out in Western Maryland that were 25 and 30 miles because they draw their patients from a much larger area. If the employer has multiple sites, and we talked about this briefly before, the radius, I don't think, should be applied to sites at which you don't spend substantial time during your employment. So if you specify a primary practice site, it's legitimate for the employer to say, we want the restrictive covenant to apply to that site, 10 miles from that site. If they have 6 sites, all over a metro area, and the 10-mile restrictive covenant applies to all 6 sites, I had one in Northern Virginia where it essentially blocked the person completely out of going anywhere else in Northern Virginia, because even though she worked at one site, the radius ran from 5 other sites. So it's really to your best interest to have the radius be restricted to a particular site. And you have to work your way around this stuff. I just recently had a physician in Silver Spring, had a restrictive covenant. She wanted to leave and form her own practice. And the employer let them know, if you do it within this restricted area, we are going to sue you. So her solution to that was she went and got a Virginia license. She's across the river practicing in Virginia for the 1 year. And as soon as the 1 year is over, she's going to come back to Silver Spring, set up her practice, and she will be competing with her old employer, but it'll be completely legal because she waited out her 1 year period. So if that's something you're planning on, is that kind of a termination, or you want to stay in that area, it's best to do some planning, best to talk to an attorney before you do it, because employers will sue. They will spend a lot of money. We had one in Annapolis where the employer spent $50,000 or $60,000 suing somebody to get $15,000 worth of damages under a restrictive covenant. And they did it because they were sending, even though it didn't make any economic sense, they did it because they were sending a message to all their other physicians. If you leave here and you set up a site in our backyard, we will sue you. So it had a deterrent effect. The time period, how long does it last after you leave? 1 to 2 years is typical. The shorter you can get it, the better. Any change you can get. So if you get presented with a 15-mile restrictive covenant and you can negotiate it down to 10, that's good for you. If they say 2 years and you can get it down to 18 months, that's good for you. Any time or distance you can shave off it is important. Okay, when does it apply? We talked briefly about, when do you have to pay your malpractice tail? A very similar consideration here. So is the covenant apply regardless of the reason for termination? Or does it not apply if the employer terminates without cause? They just let you go. If they just let you go because they didn't need you, why are they worried about you competing with them? Or if you have to terminate for cause, they didn't pay you your bonus and they were obligated and you terminated them. Why should they be able to breach the payment term of the contract, but enforce a restrictive covenant against you? So a fair number of contracts, and again, there's no industry standard, say, if they terminate without cause or you terminate for cause, no restrictive covenant, because that was their call, and they shouldn't be able to impact your profession, unilaterally without any particular reason. So, take into account, it'll take into account the length of the initial term of the contract, the absence or presence of an employer's right to terminate without cause. In addition to a restrictive covenant, there's also often a non-solicitation provision that will cover different things. It's often in the same part of the contract. So they don't want you soliciting support staff, taking the front office person, taking the biller, taking their NPs and PAs, other employees of the practice to leave. They don't want you soliciting patients if it's a patient-based practice, or contracts or referral sources. So if you're a radiology practice, they want to restrict you from going after their contracts with hospitals or managed care companies. The geographic area is often unlimited, and the duration is often longer than the non-compete. If you've ever seen, this is one reason why if you leave and you have a non-solicitation covenant, it's very important to make your presence known. Update your Board of Physicians profile. So if somebody looks you up, they know where you are. Make sure you're included in your new employer's website. Some people put ads in the local newspapers. Hi, Dr. So-and-so is joining our practice. Here's a picture of Dr. So-and-so. That's to let patients know that's where this person is. They're not allowed to solicit them, but they can make their presence known. Again, we talked about the length of the contract, security versus flexibility. Do you want the freedom to walk away easily, or do you want job security? If you want the ability to walk away easily, the employer is going to want reciprocity. They're going to, if you want to be able to walk away on 30 days notice, they're going to want to be able to term you on 30 days notice. Again, and when you're looking at termination provisions, how does the non-compete apply depending upon how the contract terminates? And termination, may override any guaranteed minimum term mentioned elsewhere in the contract. So I get physicians all the time, hey, I just signed a 2 or 3 year deal, so I've got a lot of security. I flip to the back, the termination provision says they can terminate at any time on 90 days notice. Well, you don't have a 2 or 3 year deal. You have a 90-day deal. So you need to be aware of that. One compromise I've sometimes seen, if you want, especially when you're relocating, you don't want them to be able to just terminate you with a couple months notice. So in a relocation situation, I sometimes negotiated, they cannot terminate you without cause for the first year, or maybe even 2. After that, they can terminate you without cause. Because if you're moving your family, if you're buying a new house, relocating to a different jurisdiction, you want some kind of a guarantee that they can't just terminate you on 30, 60, 90 days notice. All right, and employers almost always want the ability to terminate a physician without cause. And sometimes that's in the physician's best interest. If there's a dispute about the quality of care or patient interactions, you don't want them to write a letter that says why they're terminating you. It just looks better to say, we've mutually agreed to part ways. Other thing in termination situations is I've seen contracts that say, if you breach a material term of the contract, you can be terminated immediately. And what lawyers like to see is what we call due process, that you get a notice, a written notice of the breach. You're way behind in your charting and you agreed to keep your charting up to date. You need an opportunity to correct the breach before termination takes effect. You have 30 days to complete and close all your charts. And if you complete them, then you get to stay. And if you don't, then the termination kicks in. Another thing to think about in a termination situation is it reportable? If you work for a hospital-based practice and you are terminated, the Maryland law says that they may have, there's a whole host, at least 14 or 15 reasons for termination or separation that they may have to report to the Maryland Board of Physicians. And you want to know, is this a reportable event? If it's for some kind of malpractice settlement, is it reportable to the data bank? Because when you're making a termination decision, reportable stuff, you might have to go and explain yourself to the board under those circumstances. You might end up with a data bank report. So it's just something to think about and discuss with your counsel if you're in a termination situation. The contract will almost always have immediate termination for specific cause by the employer. Some of it's very obvious. Loss or suspension of your license or necessary hospital privileges, exclusion from Medicare or Medicaid. And exclusion from Medicare or Medicaid has a domino effect. Your contracts with Care First and United and Aetna and Coventry may all say it's a condition of the contract that you be enrolled in Medicare. And if you get kicked out of Medicare, then suddenly you're getting kicked out of United, you're getting kicked out of Care First, and it's really, really hard for you to engage in insurance-based practice. Conviction of a felony, and it doesn't have to be a felony related to your practice of medicine. It could be felony DWI. Loss or suspension of DEA number, it's just really, really hard to practice without the ability to write scripts. Death sounds pretty silly, but that's in there legally to make sure that your heirs don't have any kind of contractual rights under the contract. If they can terminate you for disability, two questions. How is that defined? So it might say inability to engage in your profession for 90 consecutive business days. It might say 90 days within a 180-day period. So they get to define disability. And also, who decides? Do they have the right to say, we think you're disabled, you're gone? Do the parties have to agree on a neutral physician to evaluate you and determine whether or not you're disabled, whether or not you can continue to perform with a reasonable accommodation? So, that can make a big difference. So take a look at that. There are often ambiguous catch-all provisions. I see this more typically in rural areas where they're more, small town, where they're more worried about their reputation. So it might say they can terminate you for any reason that the board in its sole discretion decides is injurious to its reputation. Now, that could be you got drunk and drove your car through a store window. But if you have that kind of a provision, it's really hard to fight because it gives them sole discretion to say, we think you've harmed our reputation, you're out of here. And there's really not much you can do about it. The effect of termination, again, under what circumstances does the non-compete apply? The effect of non-compete on new employment. Your new employer is going to not only ask, can you take this job? Are you under a restrictive covenant that we need to know about? You may be warranting and representing in your new employment contract, I am not subject to any restriction that would prevent me from accepting this new offer. And if you lie and take the job and it turns out you were under a restrictive covenant and your old employer sues them, they can terminate you immediately and might even seek damages. Are they going to notify the patients of when you leave if it's a patient-based practice? To me, the ethical thing is to let your patients know. They may prohibit you from doing that. They may say, these are our patients. And if they want to follow you and find out where you are, that's fine, but we're not going to tell them where you are. What I often see as a compromise is if patients specifically call the practice and say, hey, Dr. Smith used to be my doctor, they're not there anymore, do you know where they are? They will say, okay, you asked, so we'll give you their contact information. If patients don't ask, they don't tell. Termination, payment for malpractice tail insurance. Who has to pay the tail and under what circumstances? Access to medical records. If it's an acrimonious termination, I've seen people say, oh, we're not going to let you have access to the medical records. Well, first of all, that's illegal. Under Maryland law, you have an access to those medical records for continuity of care. You have them to defend yourself in a malpractice action, Medicare audits, whatever the reason is. And if they're really nasty about it, the patient under HIPAA has an absolute right to get their medical records. So if it's a contentious situation, you can just get your patients to tell them, I want to get my records. I want my records transferred to Dr. So-and-so. Do you need a lawyer? This employment agreement, it's a legal document. It's written by a lawyer for your employer, and it creates significant rights and restrictions that we've just talked about. It can impose restrictions on where and with whom you can practice for up to 3 years after you leave. The employer has usually been doing this for a long time. They've done it before. They have lawyers. Using a lawyer should not alienate your employer or cause hard feelings if the lawyer focuses on your goals and your employer is reasonable. If you get a real table-pounding lawyer who's asking for ridiculous things, that's going to cause some hard feelings, and that's not going to be a successful negotiation. Our philosophy is we want the negotiation to represent your interests, but not to leave any bad taste in anyone's mouth, to have you start your new job with as collegial a relationship as humanly possible. Sometimes we say if the employer gets upset by something you've asked for, we say, go ahead and blame us. Say that your stupid lawyer made you ask for that and you're so sorry, and you'll go yell at your lawyer. So because I'm not going to represent them, I don't care. But my goal is to have you get into your new position on a very collegial basis. The cost compared to the benefit and importance of the decision is not that significant if you know how to choose a good lawyer and use him or her. An example I give is when my wife and I bought our house. She's an attorney, I'm an attorney, but neither one of us is a real estate lawyer. It was the biggest expenditure we were ever going to make in our lives. And we hired a real estate lawyer to look over the documents and come to closing with us. He caught a couple of things that we wouldn't have caught. It cost us, some hundreds of dollars, but it was well worth every penny that we spent because he had an expertise that we did not have. Choosing a lawyer. When I was in-house at Johns Hopkins, one thing I really learned is that when you need a specialist, get a specialist. Choose a lawyer who understands physician employment contracts. A lot of physicians will choose, oh, I have a brother-in-law who's a lawyer, my neighbor's a lawyer, I had somebody who represented me in my divorce or my real estate transaction. Get somebody who understands physician practices and physician employment because it's kind of a unique animal. You can get names from the American Health Law Association in DC. Maryland has a health law section of the Maryland Bar that may be able to give you referrals. Get names from other physicians you trust and respect. Hey, who have you used? Do you like them? Did they do a good job for you? The size of the firm is not really important, but the larger the firm, the higher the rates. It's just something to keep in mind. Talk to more than one lawyer before making your decision. Make sure it's somebody you're comfortable with. And don't be afraid to ask about fees up front. One of the things I tell you is if a lawyer ever says, don't worry about the fees, you need to worry about the fees. How much is this going to cost? What we typically do is say, look, we're going to take a quick look at the contract and what your issues are. We'll give you an estimate of how many billable hours and what's our hourly rate. And we will never exceed the hourly rate without talking to you first. We'll stop and say, we've kind of hit the cap. This is what's left to do. Do you want us to continue or do you want to stop it here? But you don't want to get a surprise bill. You don't want to think it was going to cost $1,000 and have it cost $5,000. But never be afraid to talk about fees and be wary of a lawyer who doesn't want you to talk about fees. How does that work? Most lawyers charge by the hour. Again, should be willing to give you an estimate of time and total fees. Specifically ask, I would like to be contacted before the estimate is exceeded. Some will do a flat fee. We have done this occasionally. You get a resident coming out of residency who just doesn't have much money, and they say, look, I've got $1,000 bucks. I've got $1,500 bucks. That's all I can afford. And we may or may not agree to that. Not all firms will. And particularly for younger physicians or people in a cash crunch situation, can you pay in several installments or can you take credit cards? Does the practice take credit cards? You just put it on the card and pay it off, in overtime on your own schedule. Using a lawyer effectively and efficiently. At a minimum, the lawyer should review the contract before signing to make sure it accurately reflects the agreed terms. I have had numerous physicians come and say, hey, I just signed this employment agreement. Can you look at it? And I say, well, yes, I can look at it and I can help educate you, but we're not going to be able to negotiate anything. You signed it. You are bound by this now. And also, don't just have us review the contract. If you have had communications with your future employer, whether phone calls or you've got emails or you've got letters, make sure your lawyer gets all of that, because one of our jobs is to make sure the deal you sign is the deal you negotiated so that everything they promised you is in there. One of our other jobs is to make sure there's no surprises, that there's stuff in there that you didn't talk about, that they or their lawyers threw in and that you need to know about. And again, better to get a lawyer involved before you begin negotiating specific terms. One thing employers tend to not like is if you negotiate a deal with them, say, okay, I'm happy with the deal. These are my deal terms. And then you say, well, let me get a lawyer. And the lawyer comes back with 5 or 10 new deal terms. The employer may get upset, like we thought we had a deal. And now you've got this lawyer throwing a half a dozen new things at us. It's better to present it all at once. So these are the points that my lawyer and I want to discuss with you before we engage in practice, start the employment relationship. Using a lawyer effectively and efficiently, they can help you determine what you want, what you can reasonably expect to get, and how your offers compare with others in the community. I had a dermatologist who was pretty happy with her contract and happy with her salary. And I said, well, are you going to be supervising other people for dermatological procedures, cosmetic procedures? Are you going to be supervising NPs and PAs to do Botox injections, or any of those kinds of things? And they said, well, yeah. And I said, well, if you're on the hook for supervisory liability, why aren't you getting a piece of that action? And so she went back and she negotiated 30 or 40% of the net billings of any procedures that she supervised. And she didn't know that was a potential income stream. But since I had done other dermatology contracts, I knew that was a possibility. I knew to ask the question. We can identify issues you may not have thought of, and legal issues that aren't obvious to you. The way they pool the money for ancillary orders is a violation of the Stark law. We've seen that. It's kind of unusual, but so we might see that looks perfectly logical to you, but to us, it's like, oh, that's a red flag. That's something we need to restructure to make sure you're not getting in trouble for something that they have structured inappropriately. Use a lawyer effectively and efficiently. Write out what are your required terms, what do you absolutely need. I had a radiologist who was going to go out to the Midwest and be the head of radiology at a small Midwestern hospital, but their equipment was like 10 or 15 years old. And he said, you need to buy updated equipment, and you need to do it within 6 months of me getting there. We added that to the contract. And it basically said, number one, if you don't buy the equipment in that timeline, I get to terminate. And number two, you have to pay my relocation expenses back to Maryland, because that's something that I can't let my skills go. I can't work on this old equipment. I really need contemporary state-of-the-art stuff. And so we built that into the contract because that was super important to them. I talked about the other physician who maternity leave was really important to her because she was trying to get pregnant. That needs to be in the contract, depending upon how important it is. There are also there are must-haves, things you absolutely need. And then there are kind of niceties, things that would be better to have. And you have to make the distinction between those things. And sometimes you're willing to give up some niceties in order to get the things that are really, really important to you. So give your lawyer this list, copies of all documents and correspondence, offer letters, emails with deal points before he or she begins reviewing the contract. Because it's a better use of, your time. It lets us just go through everything once rather than go through the contract and then have somebody say, oh, well, here's some other stuff. Oh, I got to go through it again. You want to minimize our billable hours when we're doing that. All right, so that is the slides. I think I'm on time and under budget.
Whoops. Thanks, Jamie. I know that you've been providing these insights and this expertise for a long time. You've seen it all. And so we invite people to ask questions in chat or unmute yourself at a moment. There are a couple of questions in chat.
Sure.
And one I put in here, what if you're under contract and with an organization that had one location and you think that was the basis for the restrictive covenant? So it was 5 miles in a year, but then the organization opens additional locations, which make the restrictive covenant even more restrictive. Is that legal?
Oh, that's a fantastic question. And that's something that we typically try to address we actually had a case where somebody left. They had a 10-mile restrictive covenant. They went 11 miles away. It was perfectly fine. Then 6 months later, the practice opened up a new site down the road and said, hey, you've got to stop practicing where you're practicing. You're now within 10 miles of one of our sites. And we thought that was kind of ridiculous. But the way we try to structure it now is the restrictive covenant will say 10 miles from the site that is in existence on the date of termination. And if it says that, it doesn't matter how many new sites they put up. And we didn't really start doing that until we had that one circumstance. We thought it was kind of outrageous that someone thought it was okay to do that. This guy had gone and signed a 10-year lease on an office, done a build out, had started a new practice for a year. And they were like, oh, sorry, we're now in your backyard. You got to go.
Yeah.
And it was a backyard that they weren't competing in prior to that. So the contract should say only from either my primary site or sites that exist as of the date of termination. So they can open as many as they want after you leave. None of those will expand the covenant. That was a great question.
All right. Well, we're hearing that that has happened in Montgomery County. And
I've seen it happen. I think it's
yes.
outrageous that people would think they
Yes,
can do it, but
sure.
if you structure the contract properly, they won't be able to do that. If they resist that change, no, we want the ability to come and make you move after you've left us. That's just inherently unreasonable, and you should think whether or not you want to have a relationship with that kind of a practice.
Sure. All right, so then we have a question. This is something that's trending online, the whole issue of the FTC proposing a ban on non-competes. So does that apply to contracts for physicians interested in leaving their practice? And just, I'd like your thoughts, your prediction about whether that is going to end up passing, whether they're going to be able to apply this to physicians and to other healthcare clinicians.
That is a fascinating question. I am dying. That is kind of an earthquake kind of a move for the FTC to do that. And at first, I think it was motivated because a lot of companies like fast food companies were putting restrictive covenants on people who made sandwiches at Jimmy John's, and they just thought you shouldn't be able to stop somebody from getting that kind of low wage work. I mean, it's in the economy's best interest. And really, how many people are going to follow a sub maker from Jimmy John's to a different location at Subway? That was ridiculous. So I think that was the impetus for it. But I took a look at the initial proposal, and it includes licensed professionals. And there's whole sets of commentary on licensed professionals. I'm kind of dying to know how the medical community comes out, because a lot of physicians I don't like any restriction on my ability to practice. But the larger physician organizations are like, our large group practices depend on being able to enforce these to protect their legitimate economic interests. So I think there's going to be, number one, first of all, it's not going to happen right away. It's going to be like at least 180 days. They have to put out, draft regs, get comments, do final regs. I think the comments are going to be fascinating. I think the comments are going to be all over the place. And even if final regs come out and say it does apply to licensed professionals, I think there are going to be lawsuits over it. It's a huge governmental meddling in like financial relationships between sophisticated parties that have been in place for many, many decades. It's a big deal. So the good news, it's not, well, depending upon I've had physicians call me up and say, hey, the FTC is going to ban non-compete, so I can leave right now and go across the street. And I'm like, nope, not, And another issue is, are existing non-competes going to be grandfathered in? So you can't sign contracts with non-competes going forward, but if you signed a contract 5 years ago with one, are they going to honor that? These are all open questions, but the sort of my short takeaway is not going to happen right away. Nobody knows exactly how it's going to shake out. The comment period is going to be crazy. There are going to be major organizations that are bringing lawsuits over it. I was stunned. I was talking to another healthcare lawyer about this, and they had sort of heard about it, and they said, well, they can't possibly be talking about docs. And I said, oh, go take a look at it. They are talking about docs. And he was like, are you kidding me? I was like, so this has actually come as a surprise to the health law community that they are considering doing this. And I could be wrong, but I'm also licensed in the district, and I believe the district did something similar. They put in a broad ban on non-competes, but they had an exception for highly compensated professionals. And I think the threshold was like, if you made more than $250,000 in DC, that's enough money where you should be able to negotiate a restrictive covenant. If you're a resident who just got out of school, you're doing P's, you're making $110,000 a year, that wasn't going to affect. So DC passed a law, there was a lot of blowback, and then they kind of split the baby and said, for certain larger financial arrangements, yes, you get to do that. For the smaller ones, so how do you define highly compensated, all that? So there's a lot of different ways this could shake out, but we are going to be watching that very carefully. But part of my bottom line is nobody should plan on that becoming law, in any time in the near future. If you get to a point where you're negotiating with an employer and it's 4 months from now, check in with your lawyer or check in and see where that process is. If anybody has a much better idea of how it's likely to shake out, how it might apply to you. But right now, I can't counsel any client any more specifically than what I just said to you.
Well, it is very clear that we've got physicians on both sides of that issue. and the employers of physicians who have huge market share, and then those other physicians who are trying to do their best to provide for their family, but they have a difficult situation that they're in and want to leave. And so there is a lot of interest in that. And we informed our members last week of the hearing so that they could give comment.
Oh, so no, there are very unique situations. I had a female physician who was divorced. In her divorce decree, it said she couldn't move the kids more than X number of miles away from their original home. She had a restrictive covenant that basically meant she was going to have to drive 40 miles each way to get a different job because she was not allowed to relocate her kids. It can have huge implications for people. Yes. So, I get physicians kind of, oh, you lawyers, why did you think of these terrible restrictive covenants? I said, we didn't do this. It's the more established physicians who want to impose them on the less established physicians. We are just writing up what they asked us to write up, Right. So that's a great question, but that's kind of a cloud hanging over us that we're not going to really know the answer to for at least 6 months.
Well, we have another interesting question. Is it legal for a practice to deduct a percentage of the revenue generated for overhead if it is not specifically outlined in the contract, or does that constitute a breach of contract?
Yeah, we'll talk more about the compensation piece next week, but the compensation piece is something that physicians really need to take a very close look at. I mean, I went to law school because there was no math, but physicians are scientists. So if you have a complex bonus methodology or an expense allocation methodology, you need to know exactly how that works. It needs to be in writing. And if they have a bonus compensation methodology, I tell people, we'll get a sample bonus compensation worksheet. How is that? What goes into it? What comes out of it? What expenses are allocated against that? But if it's not in the contract, if it's, there are a couple different possible situations. One, it's not in the contract at all, and they just decide they're going to deduct a certain amount from your compensation for overhead. You probably have a pretty decent contract. And it would be, if that was their plan, it would be crazy for them to not put that in there because they're going to get challenged on that. It's not unusual at all. If you're, and again, we'll talk about this more next week, but if you're in kind of a eat what you kill situation where your whole pay is a percentage of what you bring in, it's going to be a percentage of your net collections. How is that defined? It needs to be defined very specifically because it does cost them money to put you in an exam room. They have to have a lease, malpractice insurance, support staff, EMRs, all that stuff has to get paid for. And there's nothing wrong with them saying, we have a methodology that fairly allocates those costs across physicians. And sometimes it's different. Some physicians might use a lot more injectables in their practice. And so their cost allocation will be higher because the costs of their practice specialty are higher. But that, so if it's not in the contract at all and they start doing it, I think you'd have a pretty decent case to challenge that. But again, you really, really, really need to understand your compensation methodology.
Well, I appreciate that response. Just a reminder to everyone, I haven't mentioned this, but we actually have a negotiation skills program that we're planning for March. So that may come in handy right there. So I think Dr. Servieri has a question she'd like to pose.
Sure.
Yes, this is not Dr. Christina Servieri. This is her practice manager and husband. But she is here with me. I was on separately before, but Dr. Servieri recently started her own solo orthopedic practice, and this follows directly on what you were just speaking about. We've leased space, purchased EMR, EHR, we're buying X-ray equipment, etc. Business is good, and we'd like to expand. And we were looking at bringing someone on, another provider, based on the sort of model that you just described, not an employee and not an employment contractor where we're necessarily guaranteeing a salary, but we could provide a draw, and then it gets reconciled through some formula that would be based on collections and expenses. And is that, so this would probably not be someone starting out new, but someone who has somewhat of an established clinical background in the area, doesn't have any non-competes or anything like that, but says, yeah, I'd love to come in with you. And you know, when her clinic schedule is filled, those patients can go to the other provider, et cetera. But is that a workable, feasible configuration these days for a business arrangement?
Oh, that's absolutely not unusual at all. I have a couple things to say about that. One is, you know, you should have an accountant or financial advisor who understands medical practice economics, and they can really help you sort out how do you fairly allocate, what's the overhead that you want to fairly allocate to that particular person. The other thing is when you are hiring somebody on not a salary basis and it's kind of an eat what you kill methodology, one thing we often see, and more often in relocation situations, is a practice guarantee. And sort of what that means, because the problem with eat what you kill is they come in month one, they see a bunch of patients, the bills don't go out till the end of the month. You know, Blue Cross takes their sweet time paying them. So if they're only getting, you know, a percentage of their net collections, they're not going to have any net collections for the first couple of months. So what we might see, and I'm just going to make numbers up, you know, the way to get around that and say, look, you're going to have some income day one. And this is not an unusual situation. So you might say, we're going to guarantee you $120,000 a year. So in month one, no money comes in, we'll give you $10,000. Month two, $5,000 comes in, you get to keep the 5, we'll give you 5 to bring you up to 10. Month three, 15 comes in, you get to keep the 10, but we keep the 5 to repay ourselves for the money that we fronted you. And we keep doing that until you have paid us back for the money that we fronted you. And now you're kind of, once you've ramped up, you know, within the first 3 to 6 months, they should be ramped up to full productivity. Then it's an eat what you kill, and it just depends upon what the collections are. But for those first couple months, it's going to be pretty rough for somebody on that kind of methodology. So there are contractual ways to deal with that, but we usually do that in conjunction with the practice's CPAs to sort of say, you guys figure out what the overhead is and what's a good way to allocate it. We write that up, and if there's a, you know, a guarantee type situation, you know, we can do that. We also see other situations where it's like, well, okay, we really like you. We're not going to make you repay. You're really just going gang, but we're not going to make you repay the money we fronted you. Well, that's okay. But if they have an obligation to repay, it's not income to them. It's a loan. So they don't have to pay taxes on it. If you say we're going to forgive $15,000 worth of debt, the IRS says you've just had $15,000 worth of income. So that person's going to have to pay taxes on it. So that's an option, but both sides need to be aware that, again, talk to your financial people before you do that kind of thing, because there can be financial and tax implications to how you structure it. And we most frequently like to work with, at least see what they have to say. And then once we have something that we think, that they think works, it's our job to sort of put it in place and make sure it works for you.
Terrific. Thank you very much.
So does anyone else have any questions for Jamie? Well, I want to thank you all for joining us this evening, especially thank Jamie Doherty again for your expertise, your insights, your friendship to the medical society, and your support of all the physicians. I did put Jamie's email in chat. I'm sure that if you have contracting questions, you'd like for him to look over a contract, you can contact him at that email. And then we look forward also to seeing you next week. Same time, same place, same speaker, but we're going to be talking a lot more about compensation models. So if you haven't registered for that, we encourage you to at montgomerymedicine.org. So with that, we thank all of you for coming. We appreciate your support of the Medical Society, Montgomery County, and MedChi, and we will hope to see you next week. So thanks everybody for coming.
Thanks, everybody. Great questions. Thank you.